I'm Ben Meiselas from the MeidasTouch Network. The Georgia Superior Court judge from Fulton County, Robert McBurney, who is overseeing the Fulton County Special Grand Jury, which is currently engaged in the criminal investigation at the request of Fulton County District Attorney Fani Willis of potential crimes in Georgia relating to 2020 election interference, made a very important ruling on Wednesday and made a ruling that 11 of the 16 fake electors, fraudulent electors, who fraudulently submitted their names to be certified on the January 6th electoral count certification instead of the real electors who were supposed to be certified for Biden, that 11 of these individuals who have all been represented by the same two lawyers, the two lawyers are Holly Pearson and Kimberly DeBro, that they can no longer have that same arrangement as long as those two lawyers are also representing David Shafer, who's part of that group of 11. And David Shafer is the chair of the Georgia Republican Party. And in this 7-page order that was issued on Wednesday by Judge Robert McBurney, McBurney ruled that there was an unwaivable conflict of interest because of the differing and adverse position that David Shafer was in versus the other 10 electors as part of this group of 11 fake electors. And the reason being, David Shafer was involved in really the overall coordination of the plot in Georgia to have these fake electors submitted. David Shafer was more involved, again, in the ultimate coordination and may in fact be even more culpable criminally than these other 10 electors, if indeed Fani Willis decides to pursue further investigation and eventually bring criminal charges against David Shafer or potentially against the other electors here. And now, one of the things you may be saying is, what do you mean? What's an unwaivable conflict of interest? Aren't people entitled to have their lawyers that they want? Or what's the issue with one lawyer representing 11 of the same electors? Well, or 11 clients here, the fake electors. Well, let's just think about it from a common sense perspective. Like, why would it be that these 11 fake electors who are being criminally investigated would try to have the same lawyers? Or why would the same lawyers, try to represent all of these people? Well, the likely explanation, although we could only surmise, but the likely explanation is they want to coordinate their stories. What they want to avoid is one fake elector turning on the other fake elector and telling the Fulton County District Attorney information that may be helpful to them but adverse to another one of the fake electors so that they can be less culpable or cut a deal. If they all stick together, then it makes it more difficult to cut a deal. And that could be very problematic in a criminal case, in a criminal investigation, or in a criminal prosecution where different clients who are represented by the same counsel are providing confidential information to their lawyers that could be helpful to them or hurtful to them, that lawyer may be sharing with others that the lawyer really shouldn't be sharing with others. And so what the rules of professional conduct, and all of the states have rules of professional conduct, but and they're all kind of very similar. I mean, there's what's called an ABA model rules, but then the different states have their own rules of professional conduct. The main rules of professional conduct that are at issue here in Georgia that were cited by the Fulton County District Attorney, who filed a motion to disqualify these lawyers, Holly Pearson and Kimberly DeBro, from representing all 11, is Rule 1.7 of the Georgia Rules of Professional Conduct and Rule 1.6 of the Georgia Rules of Professional Conduct. Now, Rule 1.7 involves conflicts of interest. Rule 1.6 involves client confidential information. And now for Rule 1.7, conflict of interest, what it does permit, though, is where there is a conflict of interest between multiple clients being represented by the same lawyer, lawyers, if the clients sign a conflict waiver and demonstrate what's called informed consent, that they've had the ability to seek independent counsel and guidance, and they knowingly and on an informed basis waive the conflict, that's generally enough, unless there's a situation really where the conflict is unwaivable, where the interests are so adverse to each other that ethically the lawyer can't represent all of the parties. And when that takes place, there can be a disqualification. And one of the reasons and ways there could be an unwaivable conflict of interest is where an attorney comes into confidential information from one client, and because they have that confidential information, by either withholding that information from the other clients or sharing that information to other clients, they could be causing harm to the various clients and different interests that they represent. Because you can imagine a scenario here again where one of the fake electors wants to cut a deal, another fake elector wants to go ultimately, go the distance and go to a criminal trial, and the lawyers are basically saying, look, let's all stick together, let's hold up, and they're no longer actually serving the interests of the clients that the clients deserve on an individual basis. And so here, what Judge Robert McBurney found is, look, with respect to 10 of these fake electors, all of their interests seem at this stage in the proceeding to be aligned. And at this stage in the proceeding, we're in a special grand jury proceeding. What the special grand jury is empowered to do is really just make recommendations. So we're not even at the phase yet where this is actually a criminal prosecution. It's a criminal investigation. When we get to the criminal prosecution, then there may be additional actual conflicts of interest. But for right now, we're at the stage where just recommendations will be made by the grand jury. And all of the other 10 fake electors, they seem to be pretty much similarly situated. But what the court then goes on to say, though, is the chair of the Georgia Republican Party, David Shafer, is a bit in a different position, because David Shafer was the one who was coordinating the fake elector scheme and arranging the details and was the one really pushing all of this. And so David Shafer, what basically the undertones within this order by Judge McBurney is that David Shafer probably is more culpable. He's probably got a higher risk of being potentially prosecuted than the others. And I think what's not stated in this order, but what is likely going on here, is that McBurney probably thinks that Shafer coordinated all of this. And the judge doesn't go that far, but look, Shafer is the chair of the Republican Party in Georgia. And so it would not be illogical that he would be the one having these lawyers, and he'd be trying to stick this group together of 11 to try to help himself. Now, Shafer and the lawyers deny it, and they claim, look, everybody here is not responsible for any of this. And, I did another video on this, but basically what their excuse is, look, yeah, we were fake electors, but we were only fake electors because we believed that what Trump was going to do was file cases in federal court, or file a case in Georgia federal court. And if the results were overturned through legal and appropriate means, then we just wanted to have our names submitted as a backup plan to the real electors. And in their filings, these fake electors have kind of thrown Trump and John Eastman and Giuliani and all the kind of Trump inner circle conspiracy theorist MAGA extremists under the bus and said, we didn't expect that even when they lost in court, that they would still utilize our names. Now, I call BS on that, because after they lost, as far as I know, there is no correspondence, and as far as I've seen out there in any forum, there is no correspondence from the fake electors, even up until January 6th, saying, okay, we lost in court, please take my name out, I want no part of it. They kept that going through the January 6th insurrection and waited for the outcome of the insurrection and even thereafter, and didn't remove their names at all. So I don't think it's a good excuse for them to say that, but nonetheless, that's their position. We submitted our names as a backup plan to the real electors. We believed that it was going to be challenged in federal court, and therefore we just thought we were following the law here and just reserving rights as opposed to submitting our names as fake electors regardless of the outcome. And then Trump and his team basically went rogue is what they are saying. So what they argue in their papers is that all 11 of us are similarly situated. We don't feel that there's criminal exposure, they argue, and we're all on the same playing field. But the judge disagreed. And the judge said, look, there is a difference here with David Shafer. And they go, this is on page 5. The exception is David Shafer. Given the information before the court about his role in establishing and convening the slate of alternate electors, which are fake electors, his communications with other key players in the district attorney's investigation, and his role in other post-election efforts to call into question the validity of the official vote count in Georgia, the court finds that he is substantively differently situated from the other 10 clients jointly represented by Pearson and Dubrow. His signed waiver may be identical, but his situation is not, and the court finds it to be an unwaivable conflict of interest. And the court basically says it could be unethical what the lawyers have done in representing everyone. This is what the court says. The imbalance in exposure to the district attorney's investigation makes it impractical and arguably unethical for Pearson and Dubrow, the lawyers, to represent all 11 together. And that's when Judge McBurney is saying the imbalance in exposure. What I believe he's saying there is that because Shafer has far more exposure, would these lawyers be trying to protect Shafer and then kind of dragging these other 10 individuals as part of this to try to make sure nobody turns on each other, and that what these lawyers may be doing by getting confidential information from one another and sharing that confidential information, the clients can't allow that. They can't waive that. The lawyers will be breaching their ethical duties to keep this client information confidential. So what this ruling wraps up with is the court giving the lawyers and their clients an option that these lawyers can either represent Shafer or these lawyers can represent the other 10 electors as part of this group of 11, but that they can't represent all 11 electors at the same time. Now, as I mentioned, Georgia submitted 15, or there are 16 fake electors because Georgia had 16 electoral votes, and the MAGA Republicans put a slate of 16 fake electors, so the other 5 are represented by different lawyers. But here, now these clients, and they may appeal, but they have a decision to make about whether they are going to whether Shafer is just going to be represented or whether the other 10 are going to be represented. But an important ruling, and just shows you how aggressive Fulton County District Attorney Fani Willis has been here with the investigation, the criminal investigation into the 2020 election interference in Georgia. And succeeding on a motion like this is very, very, very difficult because there is this presumption that people are entitled to the lawyers that they want. And if they sign a waiver, a conflict waiver, that overrides any potential conflicts of interest, except if it's unwaivable. So not only did Fani Willis prevail here in the motion to disqualify, but then she also got this additional response by these fake electors where they blamed Trump, and they basically tried to express their position about why there's no conflict of interest by saying, look, we're not culpable because Trump and Trump's team, they basically were the ones who went rogue. We just thought we were the backup plan, not that we were going to be used even if the court challenge is lost. And so two wins there for Fani Willis. Now, in kind of typical gaslighting fashion, you had you had the fake electors' lawyers issued a statement, and in their statement, they tried to basically say, look, all of this shows that we're not responsible at all, and we're fine, and and that the judge had basically affirmed that we were, likely innocent, which is not what the judge said at all. Here, this is what they said. They go, we appreciate the court's recognition. This is what the elector lawyers say. The fake electors. We appreciate the court's recognition that the nominee electors, including Mr. Shafer, are unified in their innocence. Like, that's not at all what the court said. And, it's also kind of the dystopian phrasing of it. The nominee electors is how they call themselves, nominee electors instead of fake electors or fraudulent electors. We appreciate that the court's recognition the nominee electors, including Mr. Shafer, are unified in their innocence. Like, the court literally said the opposite. And with the other 10 electors, all the court said is that it's kind of premature at this stage to discuss their criminal exposure simply because this special grand jury does not have the power to indict. It merely makes recommendations to indict, which would then go before another grand jury. So at the later stage, at indictment, then these issues could be revisited with the other 10. So again, just more gaslighting from the MAGA lawyers here. But big ruling, kind of a complicated concept. That's why I wanted to break it down. But an important ruling nonetheless, that these lawyers, arguably representing these MAGA extremist fake electors, acting unethically. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers thanks to your support. And in addition, please check us out at patreon.com/MeidasTouch. Consider becoming a patron of the MeidasTouch community. It's memberships that you get exclusive content, but most importantly, wherever you are in the world, help grow this independent media platform. Until next time, I'm Ben Meiselas.
MeidasTouch is unapologetically pro-democracy, and look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs. It wasn't rigged, you're just a loser. At store.meidastouch.com. That's store.meidastouch.com.